Assalamualaikum and hi everyone. I am Nur Dinie binti Shariffuddin. You can call me Dinie. I'm from Selangor and previously I studied diploma in law in UniSZA. So if you ask me what actually inspired me to study law, I will answer is because of I want to protect myself and I want to help others to be protected by law, because I believe that law is one of the powerful things that can affect someone's life. So it is a must for us to understand law very well, otherwise it can mess up your life. As I said before, I want to protect other people by law. So just now, my friend Andika just called me and asked for legal opinion as regard to his problem with Atika. So let's listen to their problem first. On 18 June, I offered to sell 3 album collection of Lee Min Ho to Atika at 1,000, and I asked her to inform the acceptance through WhatsApp before or on 20th June 2022. At the same time, I posted the advertisement to sell those collection at Shopee and Lazada, and all of a sudden, all those collections were sold out. I was about to inform Atika, but my internet connection was not good, and after that, I forgot to tell her.
Hi, this is Atika. Did you know on 19 June, my best friend came to my house and brought the album with her. Then I know that the album that Andika offered me earlier already sold out. Then the next morning, 20th June, I called Andika to accept the offer and claimed that he already breached our contract because he sold the album without telling me earlier.
Alright, Atika and Andika, I think the first issue that we need to discuss is whether conditional offer made by Andika is considered as a valid offer. Conditional offer means making offer with some condition before it could be accepted. And we can refer to the case of Ehad Marine against Sheriff Mahkamah Tinggi Malaya. In this case, the offer made by appellant was subject to 2 conditions that must be complied by the acceptor, which is the respondent. And in this case, the court held that an offer may be made conditionally, and by referring to Section 6 Clause C of the Contracts Act 1950, conditional offer lapses upon the failure of the condition by the acceptor. So, in this case, when Andika made a condition stated that the acceptance can only be made by WhatsApp before or on 20th June, then it is an effective condition. Atika must fulfill the condition. Atika, you give your acceptance by phone calls, right? Yes. Okay, therefore, the issue is whether Atika's response for acceptance to the conditional offer made by Andika is effective or not. So, first of all, we need to refer to Section 7 of the Contract Act that provide that acceptance must be absolute. And referring to Section 7 Clause B, when proposal prescribe the manner in which it is to be accepted, it must be accepted as prescribed. If the acceptance is not made in that manner, the proposer may within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accept the acceptance. Here Atika informed her acceptance on the offer made by Andika by phone calls. Therefore, Atika does not comply with the prescribed manner of acceptance as Andika prescribed in the offer, which is by WhatsApp. Hence, Andika has the right to insist that his proposal shall be accepted by WhatsApp and not call. The effect is, Atika's response of acceptance to the conditional offer is ineffective. Next, we need to discuss on whether there was an effective revocation from Andika or not. So, we need to refer to Section 4 Clause 3B of the Contract Act, where there must be actual communication of the revocation and it must be shown that the offeree was actually aware of the revocation. However, there is no requirement that the revocation must be directly communicated to the offeree. It is sufficient that it can be shown the offeree was aware of the revocation prior to his acceptance. To understand, we need to refer to the case of Dickinson against Dodds, where the plaintiff acceptor was informed by the third party on the revocation of the offer before he actually gave his acceptance, and it was held that the plaintiff was fully aware of the revocation before he accepted the offer, and then the revocation was held effective. So in this case, even Andika did not directly state his revocation to Atika. Atika actually know the album was sold out from her best friends. Hence, the revocation of the offer has come to Atika's knowledge by the information supplied from her best friend. Hence, the revocation made by Andika is effective. And when Atika responds her acceptance, even she know about the unavailability of the album, her acceptance is invalid. So concluding these 3 sub-issues, it can be found that there was no valid contract between Atika and Andika. So Andika did not breach the contract and Atika cannot claim for the album. So now, do you get it why I told you before that it is important for us to understand law very well? Yeah, so that you can know your rights. So, till we meet again. Bye. Thank you.